Good afternoon or good morning out to you folks. Welcome to the FTCA for Clinical Leaders Office Hour Session 3. My name is Elizabeth Breidenbach. I'm a meeting and events specialist based in the Clinical Affairs Division here at NAC, and I'm pleased to bring you this event along with my division colleagues. Before we get started, I would like to review a few housekeeping announcements. You have joined this online event by physically calling in or using computer audio. All attendee lines have been muted and will be muted for the duration of this event. The duration of this live event is approximately 60 minutes, including introductions, presentations, and of course a Q&A. Again, the duration of this live event is approximately 60 minutes, including introductions, presentations, and a live Q&A. If you have questions, and thank you for folks, so there was quite a few of you that submitted questions as you registered for today's session, and we do have those questions in our back pocket. We also have some of the questions from our last session in our back pocket, so we are prepared. But again, this session is for you. So if you have questions throughout today's session, comments, questions, or concerns, please paste that into the chat box. It's located in the lower right-hand side of your computer screen. Simply type your question, comment, or concern into this chat box at any time. Make sure you select the to everyone. It's a drop down. You just have to make sure you click that drop down and make sure you select the everyone section. Type your comment, question, or concern and hit enter on your keyboard. Again, it is available for the duration of the event. Feel free to test it out right now if you'd like by just letting us know where you're coming from or where you're at currently right now. We'd love to hear and see from you. But again, this chat box is going to be open for the duration of this event. Friendly reminders that this office hour is being recorded and will be available for a playback. Attendee lines have been muted and will be muted for the duration of this event. Chat boxes, of course, open for the duration of this event. We welcome all comments, questions, or concerns. And of course, you'll be presented with a brief survey after this event is completed. This lets us know how we did, how valuable this event was to you, and directly informs us of future training and technical assistance. At this moment, I'm going to turn things over to today's presenters who will be kicking things off and setting the stage, and of course, answering your questions. Molly and Marty, Keith, Yvonne, the floor is yours.
Thanks so much, Liz, and welcome everyone. We are delighted to have you here and to be in this last office hour around FTCA for clinical leaders. I am joined today, I'm going to try to do my best to moderate this session, and I'm joined today with experts from the field who you know and love, but I would love for them to still introduce themselves just in case you're new. So we'll start, at least on my screen, I see Dr. Horwood first. If you would like to introduce yourself, please.
Sure, hi. Thanks, Molly. My name is Keith Horwood. I'm a family doc with Community Health Centers in Salt Lake City. Did residency here, spent a bit of time away, and have been at the health center here since 1989. Looking forward to learning and from hearing and learning from both your questions and from Marty and Molly and Yvonne's answers.
And Dr. Johnson, thank you, Dr. Horwood. Dr. Johnson.
Hi, my name is Dr. Yvonne Fry Johnson. I'm a pediatrician by training. I was actually, Keith and I did our new medical director training together 30 years ago, but I was connected with a health center in Decatur, Georgia back in 1989 to 95, subsequently worked with the Georgia Primary Care Association, and now I'm chief medical officer at Medical Associates Plus, which is in Augusta, Georgia.
Great, thank you, Dr. Johnson. Marty? Marty, you're on mute just in case you don't know. There you go.
There I go. How's that?
Great.
Good. I got to apologize in advance if we have any more technical problems because my computer is having problems today. So I'm with Feldman Tucker Life for Fidel. I've spent 28 years working within HRSA, starting as a project officer and ending as the director of the FTCA program. I've been with Feldman Tucker now for 10 years working in the FTCA business.
Wow. Thanks, Marty. And I'm Molly. I'm also at Feldman Tucker. I've been there for almost 20 years, working with health centers on a variety of issues around risk management and compliance, including the FTCA. So we are delighted to be here. We could go to the next slide. What we did is similar to the format. If you've joined us for the previous events, we we feel like it's most helpful to take the questions that we got from the field and put them right up on the screen and just talk through them. We've tried to separate them into topic areas so that we are sort of staying in a theme in the particular questions, and we will hear from all of our presenters on these questions based on their experience in working in their own health centers, particularly Dr. Horwood and Dr. Johnson, as well as their experience in teaching other medical directors how to do their work as part of their NAC experience. So we'll start with volunteers. And the first question I'll start with Marty, which is what liability protections, Marty, are available to Medical Reserve Corps and other volunteers?
Thanks, Molly. Well, we could do a 1-hour webinar on that question, so I'll be quick. The Medical Reserve Corps is a state-based program. It's kind of a federally designed program, but every state implements the Medical Reserve Corps program. So that the specific liability protection available to the Medical Reserve Corps folks through that program can vary from state to state. So to find out what the protections are in your state, you need to contact the MRC in your state. That being said, there's still other protections available to volunteers. The first one, and the one we know best probably, is the HRSA Volunteer Health Professional FTCA program, which is a program that where deemed health centers can apply on behalf of their volunteers and send in an application to HRSA, and HRSA can approve the individual specific volunteer. So it's not like your health center program where we deem the health center and then all its employees and certain contractors are protected. Here, each individual volunteer health professional must be deemed and approved and deemed by HRSA. And there's a separate application process for that. In addition, there are other protections available to volunteers during the COVID-19 emergency. One of them is via the CARES Act itself, which provides for some immunities for volunteers who engage in caring for patients with COVID-19. Then there's the PrEP Act, which provides an immunity from suit for qualified individuals who are involved in the manufacture, distribution, administration of what they call qualified countermeasures, I believe it is, and basically we're talking about vaccines and immunizations. So there is that immunity that's available, and these immunities, they kind of overlap the one in the CARES Act, the one in the Medical Reserve, the one in the PrEP Act. And then you still have your volunteer health professional program. In addition, states may very well have passed some legislation to provide some immunities for volunteers. So it's a pretty complex field right now, where there are a whole host of different sort of protections available.
Great, thank you. Dr. Horwood and Dr. Johnson, are you using volunteers in your health centers as part of your COVID response? Or when you evaluate that, I guess I'll go to the second question too. What liabilities are you evaluating for when you use volunteers?
So
We are not using them.
Nobody's using them.
I can't say that, but we aren't. Yeah.
I mean, between the two of you, or nobody's using them. Is that because of liabilities that you evaluated, and that it's just the sort of ramp up period is too much of a task in addition to everything else?
I think we've been able to get additional funding for specifically around COVID activities. So we've been able to hire who we needed to come in. We've had people say they'd like to volunteer, but we haven't had to call them in. So.
Mm-hmm.
Yeah, that would be the same for us. Honestly, the place where the most challenge during the pandemic is really with unlicensed folks. So medical assistants, folks who we want to have putting shots in arms, and that's it's a different issue. So,
Absolutely. Absolutely.
Okay.
I think that my experience has been that I have concern when health centers are bringing volunteers on board that they're not going to have deemed, they're not going to send through the FTCA deeming process, and the volunteers may be under the misimpression that the health center is covering their malpractice liability when the health center is not, unless it's doing it through a GAP policy. So I think from a sort of operational takeaway perspective, I think it's important to let the volunteers know that they need to either bring their own insurance or that they can rely on one of these other immunities like the PrEP Act or the CARES Act, but that the health center is not providing the coverage for them. So Marty, I think you addressed the third question in your first response about the process for deeming volunteer health professionals. So in this case, if you are, and I think the deeming application is opening next week in electronic handbooks for redeeming, and I think you could add volunteers in that period, but also you use the deeming application, which is a separate application, to add the volunteer health professionals. And our understanding from HRSA is that they're turning those applications around as quickly as they can because they acknowledge the need for these to happen pretty imminently.
Right, Molly. The details on how to submit a volunteer health professional deeming application are in PAL 2019-03. That's the most recent program assistance letter HRSA has published about how to submit a deeming application for volunteers. So although it's called the calendar year 2020 volunteer deeming application, they haven't issued anything new for 2021. So as of right now, that's the instructions that would apply.
Okay, great. So what I'm going to ask Dr. Horwood to start with this question. Imagining that you did have medical volunteers, what from your perspective would you imagine to have as in orientation for volunteer workers who are working under emergency privileges?
Yeah, so first, if we're granting them emergency privileges, the obligation to make sure that they are who they say they are, that they have the training that they claim that they have, that they're competent to do the work that you're asking them to do, is really little different than it would be for privileging any provider. And you need to be making sure that you're being careful to do that, because it is still your obligation, whether you expedite that in terms of who is involved in reviewing those. There are really no places where you can say, oh, well, it was emergency, so we didn't do a background check, or we didn't make sure they really had a license that was valid. You still need to do those things. And then, there are just some obvious things about any volunteer worker that you have coming on site. And we're always challenged by this when we do our both HRSA on-site visits and Joint Commission, who does our other certifications, is, people need to know, where's the bathroom? And if somebody says code pink or code blue or code whatever, if you have emergency codes in your health centers, you need to know what they're supposed to do. Where are the emergency exits? Just sort of health and safety issues that you would do for any new employee who was coming on site. And obviously, if you're not on site, because we have been participating in some community-wide projects where, we have folks who are working at the local arena in the parking lot doing drive-through vaccinations. They need to have those same sorts of emergency services orientation to get there. So those are the sorts of things that we would be thinking about. And we have 8 different sites, and so what that orientation is site specific and different depending on where they are. But think about what they would need just to function in your setting under routine circumstances, and then a variety of sort of more common, hopefully not very common, but possible emergency sorts of situations.
Very helpful. Dr. Johnson, do you want to add any thoughts on that?
I think he covered most of it. The only thing I would add is to definitely let your staff know that you have these new people that are going to be doing stuff that it looks like they shouldn't be doing on your site. So kind of make people aware of who's on the team. We're on the team, you know.
Great point. Great point. Okay, I'm going to move on to the next category, and there's only one question, and at this point is, so this question's for Marty. Marty, is there any FTCA requirement for gap coverage for the tail risk when switching from a commercial professional malpractice policy?
That's a very good question. And when you look at all of HRSA's publications around the FTCA program, they don't address that. They don't have a specific requirement that requires you to purchase gap insurance or actually a tail policy when you're switching from a claims-made policy to the FTCA program. That being said, it's very good business practice to purchase the tail when you're switching, because if you don't, you're going to have a period of time, and you don't really know how long that's going to be, that you will have no protection. Because once your claims-made policy ends, then you're not covered anymore for claims that might arise from that period of time when you had the policy. So you need a tail to cover you in the future for what happened in the past. If you don't have that tail policy, then you don't have any coverage. The FTCA coverage is not going to go back and cover you for the past. So the FTCA program is only going to cover you from the first day you were deemed and going forward. So simply from a business perspective, a tail policy is basically a requirement if you have a claims-made policy that you're no longer continuing.
Great point. And I think that the larger point, which is no, there's not a FTCA requirement, but there is a requirement just for risk management purposes as a business that you would be evaluating that and making sure you had appropriate coverage.
Yeah, that cost is going to vary depending on the person's specialty, how long they were practicing, what the law is in your state for how long of a period there is for a claim to be made. But if I'm hiring Yvonne to come work for me and I want her to be with me for the next, 10 years, think about what it would be like if she's now getting sued from prior acts and, worrying about losing her house because she's uncovered. That makes it very difficult for me to, have her continue to bring the value that she's bringing to my organization if she's, naked and alone in a storm that I could have thought about covering for when I brought her on. So if we're bringing on people from private practice who have not found a way to cover a tail, we would put it, near the top of our list of making sure that we're taking care of them so that they can take care of our patients moving into the future.
Right. I think, and there was a question in the chat about does the health center or new provider typically cover the tail? Typically, we as the health center have done so, but the risk seems to be for the provider. And I agree that ultimately it is going to be on the provider. The health center is not going to be brought into the lawsuit, but you're going to have a provider that's very distracted, particularly in the event that they don't have any coverage. So you want to hammer that out as a requirement, and whether or not that's part of the package that you give them when they come on board, and that's factored into their compensation, et cetera. It's something that you want to make sure that you have in place.
We have the same, we have a lot of older practitioners whose practices we've just recently taken on, and we have this issue all the time, and it does get negotiated with their contract, but they definitely do get the tail coverage, whether we pay for it, they pay for it, or there's something worked out where it's kind of spread out over time how it's paid for, but they definitely get their tail covered.
It's good. It's a great question, and definitely something that you need to be paying attention to. Okay, the next category, credentialing and privileging requirements in an emergency. What is required to grant emergency privileges, and what should be included in orientation? Oh, we already handled that one. But what is required to grant emergency privileges? I put in the chat the link to PIN 2017-07, which is the PIN that describes what you have to do for temporary privileges in an emergency. So take a look at that, and we can make sure that we circulate it again if you missed it in the chat, or if you can go up, but it's laid out in that PIN from 2017. I guess my caution would be that that you ensure that those privileges are only supposed to last 90 days. So if you're beyond the 90-day mark with any of your temporary staff or people that you've temporarily privileged in the pandemic, make sure that you are bringing them into your full system.
So can I just ask a clarifying question?
Mm-hmm.
Yvonne, when you have that negotiation, then do you say, listen, you're coming to the health center, we're happy to cover your tail. If you stay for 4 years, we'll cover all of it. If you're gone in 6 months, then we're going to ask for some of that money back. Or do you have some way that you sort of split that out that helps you, not they just drop by the health center for a tail coverage payment and then disappear into the night?
Great question.
You muted, Yvonne.
Dr. Johnson, you're on mute somehow.
I'm just talking. I'm sorry. I actually am not involved in those discussions with those folks, those particular folks. And we have a business development person who does that with the CEO. So I am not involved in those discussions, but I know that those discussions occur. Sorry.
Yeah, Keith, the approach that you've thrown out here is a very reasonable way to attack that problem, and making the payment of the tail policy linked to the number of years of service in some fashion.
Okay, could we go on to the next slide? Okay, so these are FTCA coverage questions. So Marty, I hope you're ready. The first one I really love because it just reminds me of a lot of the training that we do. Okay, so there's 3 different scenarios. It says, will you clarify the criteria for coverage? Is it, I'll pause after each one. Is it number 1, employed being paid by the health center at the time of the occurrence? Well, I guess I won't pause because I have to read it in context. 2, only caring for a health center patient, or 3, caring for non-health center patients or unclaimed hospital patients while working on behalf of the health center. All of the above, others.
Okay. Let's see. I would say, I'm going to say all of the above, but I'm going to explain it.
Yes.
First off, who is protected under the FTCA program? So the health center has applied, and the health center has gotten a notice of deeming action, meaning the health center is deemed to be a public health service employee. Who else is protected then? Well, first, all of the employees of the health center, and that means anybody who gets a W-2 from the health center. It doesn't matter if they work 1 hour that year or they were full-time that year. If you're an employee, you're protected. Also, all full-time independent contractors and some part-time contractors are covered. And the part-timer contractors are family practice, OBGYN, general internal medicine, and general pediatrics. These are individuals these are people who contract individually with the health center, not through their personal corporations. Okay, so any contract with a corporation to provide services, those individuals are not going to be covered. Okay. Health center patients versus non-health center patients. The general rule is you're only protected if you care for a health center patient, and that term, health center patient, is defined in the FTCA manual. However, there are situations when you can be protected for caring for non-health center patients. And one of those is if you are taking a required hospital emergency room or on call. If by virtue of having admitting privileges at a hospital, you're required to take periodic hospital call or periodic emergency room call, and your care for the non-health center patient during that on-call period is covered. There are about 7 other approved examples of care to non-health center patients where you're protected. For example, if you are participating in an immunization campaign, then you are protected for the immunization of non-health center patients. And there are a number of others, okay? And that is a brief summary of an hour, actually a brief summary of a day and a half
2 days, yeah.
program that we do.
Yes, exactly. But I appreciate that all of those are in the same question. I like that question. Okay, for residency programs, is patient care at the hospital as part of a training rotation considered differently than covering patient care for health center patients at the hospital? For example, if a resident is on a specialty rotation under the direction of a hospitalist or other preceptor not employed by the health center and is caring or involved in care for non-health center patients, are they covered by FTCA? So I'm assuming in this question that we're talking about health center operated residency programs. And I would
Okay.
no.
Okay, so Molly, the example here then would be the health center has
health
a
center
residency program.
Right. The health center has a residency program. So if the health center, basically health center employed resident, is on a specialty rotation under the direction of a hospitalist or other preceptor not employed by the health center and is caring for or involved in the care for non-health center patients, are they covered by FTCA?
I love this question. HRSA, the Office of the General Counsel, and Department of Justice are going to say no, right? But if I remember correctly, and I'm dating myself now, but I remember correctly, back in the 1990s, a health center had submitted a particularized determination request, which is a request for approval of care to non-health center patients. And this health center was operating a residency program, and the resident was employed, and the resident was doing a rotation at another facility as part of his family practice residency, a specialty rotation. And at that point in time, HRSA had written that, yes, this would be covered under the FTCA. That being said, I can guarantee that they will deny it, and they will argue that there is no coverage, and everybody else involved in the government will argue there is no coverage in this particular case. The only time you would have coverage for this particular resident is when they are in the health center seeing health center patients or following them in the hospital, just as if they were a regularly employed physician within the health center. The fact that they're a resident, when you look at this question, doesn't make any difference really. You examine this question as you would for any employed physician in the health center.
I agree 100%. And that's
So that would mean a health center that's operating a residency needs to shop for a gap policy for those external rotations that their residents go
That's
to.
right.
Regardless of their W-2 and their.
Exactly.
Correct.
Exactly. Hospital, right. Even if they're rotating outside of a hospital at another, private practice, specialty care, et cetera, that's all going to be in the same boat. Okay. If our OBGYN has hospital privileges, does FTCA cover her if she's assisting other doctors in the hospital in surgery if she's not on call at that time, but does so to keep up her skills and have a good working relationship with the other OBGYNs? No.
Ma, this is a question that comes up repeatedly.
Yes.
And who wants to answer this?
I can take it.
Okay.
So in this situation, FTCA would not cover her because she's just assisting the doctors for surgery when she's not on call, but just to keep up her skills. Now, if she were assisting and it was obviously one of her patients, or she wouldn't, or if she were in that required care that you have to do because to maintain hospital privileges, and she were in there and ended up assisting somebody, that would be different, correct? But just going in like for planned surgery, oh, I need you to assist, this might be nice to do, they won't cover you. But if she were there actually seeing patients because it was part of her requirement to maintain her hospital privileges, and in that situation she ended up assisting a doctor, then that would be covered, even if it were a non health center patient.
I agree with
That's
that.
right. Yeah. We should point out that that's one of the exceptions. The required on-call is one of the exceptions to that health center patient requirement. And there are 7 others. And we should point out that there are certain requirements that you have to do to meet these exceptions. For example, the exception that allows you to take hospital-required call and be covered, there's a requirement in that be part of your position description. You have to have some language in the employment contract or position description for the physician that requires them to take this hospital call or emergency room call. And some of the other examples have similar kind of language. So you want to check, if you want to delve into this issue in more detail, you'll need to check further into the actual requirements of each example.
Right. I just to emphasize that, and there is a comment in the chat about it too, that these exceptions have particular documentation requirements attached to them. And the one around participating in hospital call coverage requires you to have that in your employment agreement or other employment documentation as a condition of your employment at the health center. So just like the school-based and school-linked example requires a written affiliation agreement. So make sure you're paying attention to that. Okay, let's go to the next slide. So these questions are all around risk mitigation during COVID vaccine administration. Let's start with the first question. What can health centers do to limit liability when staff or patients report adverse reactions to the COVID-19 vaccine? What tracking or follow-up systems would be advised? Dr. Johnson or Dr. Horwood, do you want to start that?
I'll take that one because okay, so the first thing is make sure that your staff have been properly trained on the vaccine, administering the vaccine. CDC actually has some trainings that you can have your staff do to make sure that they know how to properly administer the vaccines. You have a plan for how to manage the patients during the whole process of getting the vaccines. Make sure they get a fact sheet ahead of time, the vaccine information sheet, that you've done a pre-vaccine checklist to make sure they're even eligible to get the vaccine. And I'm not talking about age, like 16 over. I'm talking about have they had COVID within the last week or 2, or have they had another vaccine recently? You've got to make sure those things that are contraindications to getting the COVID vaccine are addressed. You've got to make sure you're ready for an emergency, especially if it's something like anaphylaxis. So you want to make sure people are trained on that. You have the equipment for that. You want to also, CDC has a VSafe app and a way to check in, so you can supply that information to them. You've got to make sure that you've uploaded information to your state's vaccine registry. And we have a registered nurse who's managing our vaccine program, especially with our mobile unit. And she actually calls patients within a week of them getting the vaccine and checks on how they're doing and documents this in the telephone encounter. So you want to be sure that people know that they could contact you. They know how to contact the CDC. The staff know how to do the reporting of adverse effects, and mainly having the tracking and documenting the lot number, et cetera, doing all of that stuff correctly.
Great, all great comments. Dr. Horwood, did you want to add something? You're on mute, Dr. Horwood. Sorry.
there are some additional protections provided because of the pandemic, and so I don't know how one would access that. Let's say you had received notice of an intent to pursue something. Do you know, or can you point folks towards a resource to how would they be able to assert that privilege to say, oh, well, we have our usual process, we're immune from suit because we're a health center, but now we're going to assert this additional privilege that relates to the changed rules for the pandemic.
Mm-hmm.
That's a really good question. Do you want to answer that, Molly?
No, go ahead.
Okay. If you're a deemed health center, you would submit any potential claim or suit around a vaccine to the Office of the General Counsel, like you would any other claim in the past. At that point, the United States itself, as a defendant, assert one of those immunities. Particularly, I think the one in the PrEP Act. The United States gets to utilize the same defenses that an individual would. So that I do believe the PrEP Act would apply to the United States. In any case, the protection you have under the FTCA program is the best protection. It is broader than the protections in the PrEP Act and the CARES Act. So your first step would always be to submit the claim to the Office of the General Counsel at HHS.
Agreed. Okay. For COVID, well, there was actually a question in the chat that I'll ask right now that sort of relates, which is the liability for a health center if they gave, so I'll just use the two as an example. So the first vaccine dose was Moderna and the second dose was Pfizer. What is the health center's liability there?
Well, first there has to be damage, and we don't even know that what the result of that would be.
Right.
So assuming that there's some damage to the patient, again, you have protection. If you're a deemed health center, you have the protection of the FTCA program, and the government then can assert whatever defenses are available to it. And it gets pretty complicated here. So I probably won't go much further than that because this is a new area, and how the United States defense under the FTC would mesh with these other immunities. We'll just have to see how that works.
Right, and I would just say that a corollary example would be the blood clots and the J&J vaccine or whatever the case may be. The health center should have feel assured that the strict liability of the vaccine manufacturers is not going to flow to the health center if there are issues with the underlying components of the vaccine, et cetera. If however, it's the health center's error, they don't schedule a second dose or they mix up doses or whatever the case may be, or they don't keep the temperature controls correctly. That is where the health center could have liability. But to Marty's very good point, a patient would have to demonstrate an injury that resulted from the negligence of the health center, and that negligence was the cause of the injury. So a lot of hoops to jump through to make that happen.
So we've asked this specific question because we have patients who are either unaware of what they got or were unable to get it. Perhaps they had one vaccine literally in another country and they don't have records, so we don't have access to them. And the CDC guidance has been that if you started with Moderna and then you gave Pfizer, that you should complete the normal recommendations for the vaccine that you know that they got. So if a patient came to us and say, I had a shot 3 weeks ago, but I don't know what it was, then we could offer them whatever vaccine we have available, whether it's Moderna or Pfizer, or maybe by a week or two from now, Johnson & Johnson, and complete that series, if it's a 2-shot series, as though they had not been previously vaccinated. That's the current recommendation. And the potential liability would be to say, well, you know, they got one shot 4 weeks ago, and so we gave them another shot this week, but it turned out they were two different shots and therefore it didn't work. Or they told us they had a shot, but we didn't, you know, exercise any effort to figure out that it really was Johnson and Johnson and therefore they didn't need a second shot. Those would be some potential issues, but they're really just around clinical quality. And the recommendation from the CDC is complete a series that you can document.
So you can feel comfortable that this series was given regardless.
Correct.
That makes good sense. I think okay, so the number 3 and number 1 are the same. Are dentists and pharmacists working at an FQHC covered under FTCA to administer COVID-19 vaccines? Dr. Johnson, you want to take that one?
I would suspect that the pharmacists are, but I don't know about the dentists. I'd have to pass this on to somebody else. I'm not sure about, yeah, I'm going to leave that alone. I'm going to say
Okay.
pharmacists.
I would add that it's going to depend on in the state who's authorized to be a vaccinator under their license. And so some states have extended that to dentists, some have not. So you want to be familiar with who's permitted to be a vaccinator in your state. And it seems to, from my experience, it seems to be all over the map, literally and figuratively, in terms of who can vaccinate in which state. So, Dr. Horwood or Marty, I don't know if you have anything to add on that.
Yeah, I mean, these guys can find little tiny nerves hidden all over people's faces. So it's not like they don't know which is the sharp end of the needle, but you need to know what your state allows them to do. And I know I've talked with some health centers who have done some, you know, in-house or otherwise training to certify, yes, indeed, our dental staff does know how to do. Right now, we're not letting them see very many people because everything they do aerosolizes, you know, potentially aerosolizes virus. So we're going to use them for vaccination. And a number of states have said, hey, we're desperate for people who know how to give shots. Let's extend that privilege either permanently or for a short time. But, you know, check with your local council or whoever you need to ask to figure out what's going on in your state for those various professions.
So we aren't using the pharmacists in our own center, but I know that we can, and I know that local pharmacists are doing it, but I'm not familiar with dentists doing it in Georgia.
Mm-hmm. You could probably start with the state health department too. I bet that there would be something on the website, of the websites of the various departments. No doubt that a lot of people are asking that question. Why do clinics purchase additional professional liability above FTCA coverage? Marty, that's your favorite question.
It's a really fair question, given the fact that the original purpose of the statute, the Federally Supported Health Centers Assistance Act, was to eliminate the need for health centers to purchase malpractice liability insurance. Yet in 2021, over half the health centers purchase gap insurance. So why is that? And one of the reasons why is the manner in which the program is administered. You have 3 different agencies involved. You have HRSA, which does the actual deeming and determines that you're deemed in the program, and who has a habit of making pronouncements about what's covered and what's not covered. You have the HHS, Office of the General Counsel, that once a suit is filed against the deemed individual or health center, they determine whether it's covered or not under the program without a lot of consultation with HRSA. HRSA's role in that is very, very limited. And then you have the Department of Justice, who, if this claim moves on to the status of a suit against the United States, the Department of Justice takes over, and they seem to have the opinion that they determine who's covered, and they can basically overrule what HRSA has said, and we've seen this happen. So there's this lack of real certainty in the program that causes folks to buy gap insurance. Another reason they buy gap insurance is because they know they're doing, you may know you're doing something that is likely not covered. So you want to have that protected. And I think the third real reason is that the government itself, and probably all three of those agencies, don't really understand the nature of your immunity under the law, and they confuse it with the waiver of the United States sovereign immunity, which are two different things. So the short answer is they buy gap insurance because of underlying uncertainty in the protection afforded by the FTCA program.
Marty, could you spend another minute just describing, I mean, I think it took me a couple of years, if I'm being totally honest, to fully appreciate the difference between the waiver of the sovereign immunity and the immunity. I think it's a really important concept that you should, as health centers, have floating around in your head. You don't have to apply it on a daily basis, but it really informs when you find yourself in a position where the Office of General Counsel or the U.S. Attorney's Office is saying that you don't have coverage for a particular case, why they might be wrong, and why you should not necessarily take that answer as to be correct right out of the gates.
Yeah, sure. I think the best example of this is that we call this the FTCA program, the Federal Tort Claims Act program. But the Federal Tort Claims Act doesn't grant you any protection at all. The Federal Tort Claims Act was a waiver of the United States sovereign immunity back in 1946. And what that law did was it permitted individuals to sue the United States for the negligence of their employees. And that was a very limited waiver. It has a lot of limitations. But prior to this law, prior to the passage of the FTCA, if a government employee was negligent and damaged you, let's say you got run over by a HRSA employee while they were on federal business in a federal car, you had no recourse. You couldn't sue the United States and recover. So the Federal Tort Claims Act was passed to allow you to have recourse for the injuries inflicted on you by negligent government employees. Okay, now where does health centers come in this? In 1991, Congress was concerned about the amount of money health centers are spending on medical malpractice insurance, so they passed the Federally Supported Health Centers Assistance Act. That law created a scheme where health centers could apply to HRSA and be deemed to be public health service employees. So once you submit that application, you're deemed to be a public health service employee. And what does that do for you? That grants you the same immunity from lawsuit that other public health service employees have. And further, it states that the individual, the patient, their only remedy for your negligence is a claim against the United States under the Federal Tort Claims Act. Okay? This immunity you have via the law as a public health service employee is very broad. It's extremely broad. The waiver of the United States sovereign immunity under the Federal Tort Claims Act is more limited. So what that basically means is there are instances where you could be immune from suit for some action, yet the United States hasn't waived its sovereign immunity. And the patient in that situation has no remedy at law whatsoever. And that's where the government gets confused. They think that your immunity is the same as a waiver of the United States sovereign immunity under the FTCA, but it's not. It's much broader, and it's that waiver of it's your immunity that's under Section 233A of the Public Health Service Act. It gets pretty technical, but that's the difference. Your immunity is bigger than the waiver of the United States sovereign immunity, and that's where the government gets confused.
Thank you, Marty. That's really helpful. And actually, there's a question or a comment in the chat that I think I also would like you to clarify when you talk about immunity, because the comment is that we don't talk about how this negatively impacts legal access to vulnerable populations. Since they are poor, they can't sue for malpractice because the only option they had was coming to us. So just clarifying that immunity doesn't mean that patients who suffer an injury because of negligence can't recover money damages. It just means that it doesn't come through the state court system. So do you want to just touch on that?
Right. Yeah. I think there's also some concern in that comment that the populations we serve, the really underserved populations, don't have access to legal services to bring FTCA suits, and that could be a possibility. I know in the past, 20, 30 years ago, that was a considerable concern. If that's changed and how that's changed, I'm not certain, but it could be an issue. There's no data, around FTCA suits, by who brings them. If you assume that all of the patients we serve have some legal access vulnerability, and that's maybe a very overbroad assumption. I don't think that we see that there are a lot fewer suits against health centers than there are in the private sector. All the limited data we've seen is that claims against health centers are somewhat similar to claims and suits filed against the rest of the healthcare universe. But really I don't know of anyone who's done any kind of really good analysis of that. HRSA does have the data that would let someone do that kind of analysis and see if, hey, we're getting sued a lot less, and perhaps it's because our populations don't have access to attorneys. But I don't know that.
I don't either, and I think the other point is in the chat, which is also really a really astute point, is that the lawyers may not, because lawyers aren't necessarily medical malpractice plaintiffs' lawyers are not necessarily comfortable with being in the FTCA world, being in federal court. So you're limiting the exposure that way as well. But we see if they spend any time looking, it's actually much easier to file an administrative claim than it is to file a lawsuit. But I get it.
Yeah.
Okay, so let's go on to the next slide. I think we have about 6 minutes. Two on telehealth. With regard to telehealth, can a provider do a telehealth visit if they are licensed in Massachusetts, but the patient is in another state, maybe because they are just a student, or sorry, because they are a student or just traveling?
Every state has their own licensing rules. And prior to the COVID-19 epidemic, most states required that if you're providing a service to an individual in their state via telehealth or otherwise, you had to be licensed in that state. So if you were in New York and providing care to a patient who's physically in Massachusetts via telehealth, you had to have a license in Massachusetts and probably one in New York. Since the beginning of this epidemic, many, if not most, if not all states have modified those requirements and eased those requirements significantly. However, there has not been a uniform practice in that, and every state may be different. So the answer to the question is it depends. You can get information on every state's requirements at the Federation of what's that website? Federation of State Medical Boards.
I'm going to put it in the chat, Marty.
Okay.
I'll put the link in the chat.
I'd like to throw something in on that. Is you also would not necessarily know where the person really was. I mean, they could tell you anything. We're not tracing where they are.
That's an issue. Absolutely.
And I don't recommend tracing it. I recommend not really spending any time investigating it.
Right, I'm just saying that, yeah.
Yeah, no, but you're absolutely right. I had a health center that found out that the patients had gone back to Peru and
Oh,
they were
wow.
they had no idea.
Right.
So
Well,
yeah,
that's probably not as big a problem, whether or not the government of Peru is going to be able to
exactly.
reach
But
across.
just the point that you
reach
could be, you could have left the United States and still be getting your telehealth care. So
well, what we have had a number of questions about health centers who had physicians who were in other countries and wanted to do telehealth visits with their patients back, in the state where they practice. And I think the answer to that thing that would concern me about that is what are the rules of the country that you happen to be in, because they could be very different from our practice in the United States. I think we had someone who was in Pakistan who wanted to do telehealth visits back home in the U.S.
yes.
And quite frankly, I have no idea what the Pakistani government would think of that. So
Well,
I
the
would
same
be
thing
very
is
cautious.
if you, the practitioner, were in a different state than the state where you are actually licensed, but you were telehealthing back to your patients in your state, that's another situation that could arise.
That's where you'll
Right.
have to look at the rules for the state where you are in.
Where you
Yes.
physically are, yeah.
Yeah.
We had a health center that had a provider who wanted to provide hormones to a patient who had moved to Jordan, a minor patient who had moved to Jordan, and navigating the laws in Jordan around that with a provider in the United States is almost impossible. Anyway, so okay, this question is for Dr. Johnson and Dr. Horwood. Are there any common practices emerging to reduce the risk for care provided over the phone? Anything that either of you have seen out there?
The only thing I know that we've tried to do is make sure we know who we're taking care of. Well, okay, not so much over the phone. Well, over the phone, if we're, this is a really good question. If we're doing telehealth and we're actually looking at the person, we like to know that we're looking at the person we think that we've treated before, the person we have the picture of in our EHR. I don't have a specific thing for over the phone, so I'm going to pass over to Keith. You have something specifically for over the phone?
Yeah, and we try and do what we can to make sure that we're matching. So for over the phone, we would try and still use 2 identifiers, name and date of birth. If it's on the phone, we usually will also confirm their address, because they could tell you any one of those things and not have them be true. Because we have pictures when we're doing telehealth, then at least one of those items is a photo ID. But I would say in general, the same things that you do for all of your visits. Do good documentation. When there's shared decision making, document that you did shared decision making. Document as well as you can. We also have a disclaimer at the start of our visit that every patient hears for every telehealth visit that says, we are not representing that we can do the same thing in person, same thing over telehealth that we would do in person. And by participating in this, you recognize that we're not supplying the same standard of care as if you were in the health center where we could measure your blood pressure as opposed to you measure your blood pressure, or where I can listen to your lungs, or I can, etc. I don't know if that's important or not, but we've just said it at the front. We're doing the best we can to help take care of you, but nobody's pretending this is as good as being in person.
Right. And a telehealth informed consent that describes that as well, that telehealth may not be the best modality for particular concerns, I think is helpful as well. So we're at time. One of the last 2 questions is actually not an FTCA question, so I don't feel like we needed to get to it. That's why I'm rationalizing, at least. And the last one, I think we could just knock out pretty quickly. Providing vaccines to patients in the home setting. Can CMAs provide this service? Can we collect labs during home telehealth visits? can the CMA draw labs in the home during the telehealth visit? So this is again going to go back to what CMAs are licensed or certified to do in your state, and your frankly your own training of your medical assistants in your health center, and then the rules in your state. So my suggestion would be to go back and start there to understand what makes sense. And I think with that, I think we are out of time. So I will hand it back to Liz, and thank you. Thank you so much to our panelists for being here. That was a lot of fun to do that every day if we had time. But we'll look forward to seeing everyone next time.
Perfect. Katja and team, did you want to say anything about our upcoming events or in regards to these resources that are on the screen before we close out officially?
We will be in touch. We'll send this PowerPoint with the listing of all the referenced and additional resources out, including the link to the recording and the PowerPoint. Thank you.
Perfect. Thank you so much. And before we close out, again, I'm going to give everybody a few seconds. There's a few upcoming webinars that NAC is hosting. You can find this on our website on nac.org. If you have a smartphone next to you, so Android, iPhone, you can actually take your camera up to the screen and register for these events literally directly on your iPhone right now, or again, Android, whatever you decide to use. So we've got a webinar coming up tomorrow with HRSA. More to come on that, more details when you scan that QR code right there. Alternatively, the Million Hearts team has two events coming up, one on May the 5th and one on May the 13th. I'm going to give a few seconds to scan those guys in if it's something that you guys are interested in. And then last but not least, starting next week, we have our Business Continuity Institute. All three of these webinars that I just mentioned are absolutely 100% free. Feel free to, again, like I said, register for these events, pass them along to your colleagues. Again, you can find further information on our webpage in regards to registering, more details, essentially your learning objectives and takeaways. With that being said, thank you guys so very much. We will reach out to you via email, again, with the survey information, with the recording, with the PowerPoints. Please do give us a few business days. We want to make sure that we ever get everything trimmed up. For some reason, we were unable to answer your questions in the time allotted. An attempt will be made after the event is completed. Thank you guys all so much. Have a great day. We'll talk to you soon. Bye, everyone.
Bye.
Thanks, everyone.
Thanks, everybody. Bye.
Thank you.